Thank you for joining me today for the webinar. Most of us are signed on now, so I am going to get started. I want to be respectful of your time while also getting you what I hope to be some helpful information about divorce and the divorce mediation process. Just one quick housekeeping matter first. If you would like to ask questions, right now to protect your privacy and your confidentiality, you are all muted and not visible as participants in this webinar, but you can still ask questions. If you click on your screen, a toolbar should pop up and you will see that there's a Q&A icon. You can click on that. Feel free to ask me any questions during the process. I will be happy to answer them. Often I wait until the end of the webinar, however, just so that often I find the information is already in the webinar materials and your question will be answered in that fashion, or at the end, I will go back and answer any questions, but I want to, again, be respectful of everyone's time, and since some questions can be very particular to someone's personal case, I usually will just give a little dissertation on the questions at the very end. But first, thank you very much for joining us today. First, I would just want to give you a little background on me and who will be giving you this information, so you have a little context around the information that I give you today. My name is Susan Guthrie. I am a family law attorney and divorce mediator. I have been doing this for almost 30 years, and I am currently located in La Jolla, California, where I have a boutique practice that solely focuses on divorce and family mediation issues. And I also do online dispute resolution, which means that I work in an online format with parties in order to help them resolve their divorce issues or family law issues. So that's a little bit about me. If you want to know more, there's more information on my website, or you can feel free to contact me at any time. But today, my goals for this webinar, I realize people who are signing in today are usually at a point in time where they're going to be making some decisions about how they want to go forward in their life. So my goal is to give you some information that will help you make those decisions. So today, I'm hoping to give you some basic information about divorce, what divorce is, and the mediation process as it applies to divorce. I always just mention that mediation is really a dispute resolution process that is applicable to almost any type of dispute. It could be a landlord-tenant matter, it could be a contract matter. It's really available to anyone who has a dispute with at least one other party in an effort to resolve those disputes. But today we'll be focusing on mediation as it applies to divorce. And then I also just want to discuss with you some of the benefits of choosing mediation over the more traditional approach of litigation as a way of resolving your divorce. I think it's important, and one of the reasons why I do this webinar every month is to give people information so that they know that there's more than one path to go forward. And then today I will also, each month I have sort of a bonus topic of information on something that I think is relevant to the divorce process. This month I'm going to be covering custody and parenting plans. So that information will be at the end of the webinar. If it's something that does not apply to your case or you're not interested, you'd be able to sign off at that point in time, but I will be going into that topic. Next month's topic, just so you're aware, will be spousal support or alimony. So for today, first, what is divorce? Many people are confused by it, and it's many things. But from a legal perspective, divorce is a formal process that terminates this legal status that was created when the parties married. So when parties get married, there are certain rights and obligations that are created as a result of that marital status. A good example of the rights that are created would be that the parties have the right to file their income tax returns jointly, which usually confers some sort of benefit tax-wise to them. So that's a benefit. an obligation that arises as a result of the legal status as being married is that most states allow a third-party creditor to pursue one spouse for the necessary expenses of the other spouse. So things like their health expenses, medical, food, clothing. What that means is, so one spouse goes to the hospital can pursue the other spouse, the one who did not get the medical services, for the expense of the other spouse's medical services. So that's an obligation that arises as a result of the marital status. So the divorce process itself, at least as it pertains to the legal process, is ending that status. So we can end it in a point in time when the divorce is finalized. But because of all those rights and responsibilities that were created at the time of the marriage, we now have several issues that need to also be decided or worked out in order to truly separate the parties. And those fall into the three broad categories that you see here. The first is property settlement, the division of the marital estate, the assets and the liabilities the married couple created during the time of the marriage. So those need to be identified and they need to be divided between the two parties. In cases where you have minor children, and in most states that is children under the age of 18, you will also have to be required to establish both the custody of your children as well as access schedules, meaning where the children are with each parent, when they are with each parent, and those are to be established in the best interest of your children. And the third broad category is sort of the going forward sharing of income section. That would be the support issues. If you have minor children, there will almost certainly be some sort of child support order. And in many cases, it's appropriate that there is some sort of either spousal support order or alimony. So those are the three broad categories, I would say, of issues that face every divorcing couple, with the exception of if you don't have minor children, you certainly don't have to establish custody and access schedules. So there are only two ways that you can resolve these divorce issues at the time of a dissolution action. The first is that you do it by agreement, which truly means that in some fashion, you and your spouse come to an agreement on all of those issues we just outlined. The property settlement, the child custody and parenting issues, and the support issues. Somehow the parties work that all out, they have an agreement. If they cannot work out an agreement on all of the issues, or at least most of them, anything that is unresolved between the two of them will be decided by a judge. And that's really the trial phase. That's the part that we see in a courtroom where, you know, in the picture here, the man in the robe or the woman in the robe with the gavel is going to hear testimony, see evidence, and that person, who's essentially a stranger to the two of you and has only heard what is able to be presented in that courtroom, is going to make the decisions for you about who gets what, who pays what, how you're going to parent your children, etc. So I think you can tell just from that description, that's not an optimal outcome. Most people do avoid that. I'm happy to say that only about 5% of divorce cases nationwide actually go to the trial phase, where a judge is required to make those decisions for the parties. Which means that in 95% of the cases, somehow the parties do work out an agreement on all of their issues. And that's really the favored and most optimal outcome, is where you're making decisions for yourself rather than having the judge do it. So then the question is, how do you come to that agreement? You know, how did the parties figure out everything they have to talk about and then figure out what they're going to do about it and come to an agreement, which is not that easy in all cases. The first method, excuse me, is the one that I think is what most people think of when they think of divorce, and that's the traditional litigation process. This would be the default model, and this is where both parties go out, They retain an attorney, individual attorneys to represent them, and the attorneys lead them through a formal proceeding of discovery, negotiation, trial preparation. In many cases, there are pretrial issues and orders that are handled. And you proceed through the process toward trial, because trial is always the culmination of the litigation process. But hopefully you come to an agreement somewhere along the way. This is a process that is always available to the parties. So if you do not start with litigation and you start with some other process to try and come to an agreement, you always have the ability to fall back on the traditional litigation process. But it is not the only way you can go, and there are some drawbacks to this process. So first off, it is an adversarial model. It is set up as a traditional lawsuit, just like any other lawsuit that gets filed in court in a civil proceeding. It's plaintiff versus defendant. It's one party versus the other, one party seeking something from the other in an adversarial fashion. And that is because at its very core, going back to what we were talking about, divorce being a judicial process to terminate the legal relationship, it is a legal proceeding. It is a lawsuit. And so the adversarial model or the litigation process is set up on that model. So you have one party advocating for what they want, trying to beat the other side who's advocating for what they want. So it does not set up in a familial setting a very good premise for cooperation and collaboration for going forward. So it's also a coercive process. In the litigation process, if your attorney wants, say, information, discovery, you're doing the discovery process, and your attorney on your behalf wants the financial records of the other side. There's a formal process that they're going to go through of filing a request for disclosure, or they can send out subpoenas, or they can notice depositions, and all of those are actions are compelled. The other party must comply. If they don't comply, sanctions can be imposed. And the ultimate process here is that everything is compelled, and if things are not done properly, things are imposed on each of you, sanctions and negatives. So it comes at it from not that the people are coming to the table willingly or cooperatively, but it's being done in a coercive manner. Litigation is extremely time consuming, which leads to it being extremely expensive. And as a result of it being adversarial and coercive, it's very divisive. It's pushing the parties further apart from a point where they're not usually starting out to get too close together. I mean, if people are coming to the point of divorce, there are already some issues there. And instead of helping them to move forward in a positive way, the litigation process is really set up to pull them further apart. Because of the courts are overworked, overburdened, have limited resources, it just takes a very long time to get court dates to move through the process. Because your attorneys are busy professionals, it's also just time consuming to work into their schedules. And because your attorneys are handling every single step of your case for you, it is very expensive. So you pay your litigator, you pay your representative attorney by the hour. And usually, when I was litigating, I was billing in 6-minute increments at, hundreds of dollars an hour. So that means when my client called me, I billed them. When I then, as a result of that call, called the other attorney, I had to bill my client. Then when the other attorney called me back after speaking to their client, I had to again bill my client. When I went to court with my client and sat, because we were not the only people on the docket that day and we waited for our turn, I had to bill my client. I had no control over that. The client had no control over that. And it drives the expense of a litigated divorce up just very, very quickly, and it can get out of control quite quickly. And the final, issue with a litigated divorce is that it sets up this institutionalized conflict cycle. And a friend or a colleague of mine used that phrase the other day, and I thought it was just so well suited to describe what happens here. So when you go through a traditional litigation process, what you are learning and what the cycle you are setting up is that when you have an issue with your spouse, or in the future your former spouse, you have set up a cycle where when things come up, you go to your attorney for your attorney to resolve them for you. And so you have not in any way moved forward to set up systems or ways of working together to try to resolve things. Everything has been done from this perspective of your attorney being your headpiece, you're being your speaker, your advocate, and handling it for you. And that sets up a very cyclical process, because nothing stays static in your life. You will go through the divorce process in most cases, and that will, in many cases, not be the end of things you need to discuss with now your former spouse, especially if you have children. Their lives are not static. Things will change. You will need to work together in the future to either modify your agreement, make changes, come to agreements, and going back to your attorney and going through that cycle repeatedly of starting the adversarial model over and over again is not necessarily a way to move forward and reduce conflict in your lives. So that brings us to the question, if not the litigation process, what other options do you have? And that takes us to the idea of mediation, or the concept of mediation as an alternate method for resolving these issues that we've identified in your divorce. So that goes back to those three broad categories. And instead of both of you hiring an attorney, mediation offers you a different pathway with different benefits that allow you to come to the same conclusion, which is hopefully, as it is in 95% of cases, that agreement that you and your spouse reach on all of those issues of your divorce. So I'm just going to talk a little bit about mediation and some of the benefits of the mediation process. The first is that it is completely voluntary. From the start, just the decision to go to mediation requires both parties to consent and to have a buy-in for why they want to be there. Often it's a different reason. It doesn't have to be the same reason. The key is that both of the parties agree that this is the way they want to go forward. This is how they want to resolve these issues. That's different than the litigation, as we talked about, which is completely compulsory, and you are forced to either participate or decisions are going to be made without you. Another key component that differs slightly in mediation than it does from litigation is that the two participants, the spouses, make all of the decisions in the mediation. And that's really key, because unlike in a courtroom where a judge would make the decision for you, and unlike where your attorney is negotiating for you and just making judgment calls along the way, in the mediation session, the two parties are either sitting in the same room or in an online forum. We're all like we are right now in a webinar, but everybody is, together in the video conference, and decisions are being made by the parties in real time. And so there is no outside party telling you what to do. The decisions that you make are the ones you and your spouse decide are best for both of you and for your family. So if you have children, the decisions are what you decide are best for the two of you. Your one point to note, your mediator does not make decisions for you. That is not the role of a mediator, and many people will misunderstand the role of the mediator and think that they come into the mediation and the mediator's like a quasi-judge. The mediator will hear both of you speak, and then the mediator will tell you what to do. And that's not really their role. It's really the participants that get to make all the decisions. And that's really the best possible outcome, because again, then you've picked and chosen what you can and cannot live with and what is best for your family. Mediation is much more cost efficient and less time consuming than litigation. And this is really, truly one of the biggest benefits, which is not insignificant, because living in the limbo of going through the divorce process is very taxing, very stressful. So the sooner you can resolve these issues, the better, as well as the cost. Going through divorce is already a time of financial stress It is a time when finances are strained. You are separating, in most cases, into two separate households with the same amount of money. And so the huge expense of litigation is just another additional stressor. Mediation is private and it is confidential. Those are two separate things, both very important and hallmarks of the mediation process. It's private in that it takes place between the participants only, usually in your mediator's conference room, or if you're in the online setting, it would take place in that video conference. But that it is not in a public courtroom, it is not in a public forum. And in fact, in California, most often parties do not even need to go to court to finalize their divorce, meaning if they are mediating their divorce, they can, from start to finish in almost all cases, never go to court. All the paperwork is submitted outside and everything would just be finalized either, again, in the mediation room or in the online mediation room. Confidentiality, on the other hand, is actually a legal privilege that the law provides for participants in mediation so that they can come into mediation and know that whatever they discuss there, any offers that they make, any progress that they are making toward trying to reach settlement could not be used against them in a courtroom down the road if for whatever reason they were to fall out of the mediation process, if they were unable to resolve their issues. And honestly, I think it's the statistic is that over 95% of people who go to mediation do reach an agreement, but there may be one issue or two issues that go to litigation. If you were unable to make a final agreement on those, that is not anything that you say in the mediation setting, things that are provided in the mediation setting, those are not able to be used against you in a courtroom subsequently. And finally, mediation is extremely well suited to a team approach or a collaborative approach to provide support to the two parties going through the mediation. And that means you can bring in outside resources as needed, not needed in every case, but if they are needed, in order to support the parties, give them information or additional resources that they might need, again, so that they can make those important decisions about how to go forward. Some of the common team members that might be brought in, other professionals, are mental health professionals, marriage and family therapists. In a case where we have children who are exhibiting distress, maybe because of the divorce process, maybe because of other reasons, it may be helpful to have the input of an MFT so that we handle developmental issues or parenting issues in an appropriate fashion in the children's best interest. Other cases where parties are having a difficulty with communication, sometimes an MFT can be very helpful in helping establish new patterns of discussion so that they can move forward. So that's one team member who could come in and participate right in the mediation sessions to help the parties move forward. It sort of is a way to remove roadblocks that might come up or provide assistance. Another professional that is often and very helpful in a divorce mediation is someone called a Certified Divorce Financial Analyst, CDFA. And the CDFA is a financial professional who has specialized training in the financial issues that arise from a divorce. And that can be complicated tax issues, that can be stock options. There are all kinds of things that might come up, pension plan evaluations, all kinds of things. That it's helpful for the two parties in the mediation to have some additional outside financial information to help them make their decisions. That, again, is also something that the parties can decide on as the process is unfolding, and the team member can be brought in a collaborative fashion, helping them both, being an equal support to both, to help them to have the information and support they need to make their decisions. The last team member that we often may see maybe participating in the actual mediation sessions, maybe assisting a party outside of mediation would be a consulting attorney. And I know at this point, most people say, wait a minute, you know, we're not litigating. Why do we need attorneys? And I would just say the difference is vast between a litigation representative counsel attorney and a consulting attorney in the mediation process. The consulting attorney's role is again supportive, like it was with the other two professionals, the mental health and the financial, really to come in on an as-needed basis to assist their client with direct legal advice. And sometimes it's help with negotiation strategy. Sometimes it's coaching through issues. It can be a myriad of different ways to help. And those can all be, you know, discussed with your mediator and in the mediation process. But again, it's a supportive role and it's as needed. So it's usually just paid for by the hour. It does bring up an important distinction between a consulting attorney and the role your mediator plays. And I always like to make sure people understand this. So your mediator, although they may be an attorney like I am, they are not acting as an attorney in your mediation process. They are there as a neutral facilitator of your negotiations and discussion with your spouse in order to resolve your issues. They are there to support you both equally, and they are not there to take sides. They are not there to give advice to one party that might be to the detriment of the other party. That would immediately breach their neutrality, and they're really there for both of you. So sometimes in the mediation process, questions will come up that are particular legal questions to one party's perspective. And that's where that consulting attorney can be very, very helpful, because if you have your attorney, you can ask them those questions, get the answers, again, specific to you, and then you're able to come back to the mediation and make decisions. It doesn't allow that uncertainty or that lack of knowledge hold you back from making decisions, because you get your answers. So it's very helpful. So mediation is a process that has a large number of positives for the parties who go through it. Now, there are 3 phases of the mediation process itself. So if you were to choose to go through mediation, this is roughly the path that you would follow regardless of your mediator. These are the things that need to get done. The first, you identify the issues that need to be discussed between you and your spouse. You discuss those issues and you come to an agreement on those issues. Seems simple, but let's just dive down a little bit on them so that we have a good understanding. So step 1 is to identify the issues. This is a fact-finding phase. And this is the gathering, it's the sharing between the two of you of all relevant financial and personal information. Now, the personal information is really things like, how long have you been married? Do you have children? Certain relevant information that goes to helping identify the issues. The issue of how long you've been married can have an impact on, certain when assets were acquired, how long the marriage has been for support issues. Do you have minor children? Do we need to discuss parenting plans and custody? So the personal data is from that perspective of supplying the basis for identifying some of the issues that need to be resolved. And then importantly, on the financial side, regardless of whether you go through mediation, litigation, or any other process of divorce, all states require something called full and complete financial disclosure between the parties. Now, that means something different in every state, and that would be information you would get from your mediator. But it is a requirement of a valid divorce process. So very importantly, one of the first things your mediator will do with the two of you is help you to pull together, to know what you need to pull together, and to facilitate your exchange of that information. I mean, that's a very important part for your legal process. It's also a very important part for that identifying of issues process, because with the full disclosure of your financial picture, Your mediator is then able to formulate a roadmap or an agenda for your mediation process, highlighting all of the issues that you and your spouse need to resolve in order and come to an agreement on in order to finalize your divorce proceeding. So that goes back to those three broad strokes of things. You know, what are the property issues? So what assets do we have? What liabilities do we have? What the children, you know, on the custodial side of things, what incomes are we dealing with on the support side of things? So it allows your mediator from the start, at the end of the fact finding, to start your then negotiating phase off with a full list of what needs to be discussed. And that takes us to that next step, which is step 2, which is the discussion of your issues. And this is really where your mediator really comes to the fore, because this is the meat of the process. This is now where we know what we need to talk about, and we need to dive down into what all of your particular issues. Again, always with the goal of coming to an agreement so that you're part of that 95% of parties that are going through divorce who go forward in the end with an agreement. So once you've identified, or your mediator has identified the issues, their job is to educate you, both of you equally, on the law pertaining to each issue. Now, I know I was just talking about how they do not give you legal advice. They do not. That's not what I'm talking about here. What they are here to do is to give you the basic law as it pertains to each issue you need to resolve between the two of you. So that's, what does the law say? What are the statutes? What is the case law? How has this been adjudicated in the past? How might a judge look at this? What has your mediator in their experience seen? But this is not given from a perspective of, and so you should do this, or so you should do this to either spouse. But it is to give you some context for making your decisions. One of the hallmarks of mediation is that, unlike in a courtroom where a judge is required to apply the law as written, so that means in certain instances a judge doesn't have discretion to do certain things, in the mediation process, you and your spouse do have the right to do things that vary from the law, or come to an agreement that varies from the law, if you feel that that is what is better for your family or your situation. Bottom line is, unless it's illegal or against public policy, you two can agree to anything that you think is appropriate. A judge is not going to disrupt that, even if it's something a judge could not have ordered for you, as long as a judge feels that you've made an educated decision to do that. And that's the important part. So it's important that your mediator educate you both properly on what the law is, so that even if you choose to do something different, you're able to say, but we understand that that's what the law said. Another important role for your mediator in the discussion process is to make both of you aware of all the, what I call, sub-issues that flow from the broad stroke issues. So again, the property settlement, child custody, support issues. As an example, one of the property issues is often the marital residence. So yes, we know there's some real property and there needs to be a decision about that. Well, it's broader than just who's going to get the house, because that flows from that as well. If one party is going to keep the house, what happens with the mortgage? Is it joint? Do we need to refinance? If you're going to both stay on title, how will expenses be paid for? It's a joint asset. If it's going to be sold, how will it be sold? How will you handle the process of the sale? Who gets to live there until it sells? How will expenses be paid until then? You know, a myriad of those details. How will the proceeds be divided amongst you? So that's just one issue under assets to give you an idea of all the sub-issues. So your mediator is there to take you through all of those, guided by the decisions that you're making. But in some cases, you may not know what, say, you want to do with the marital residence. So your mediator can lay out a variety of different, you can keep it, you can sell it, if you can keep, you know, a lot of different things you can do. The mediator is there to facilitate your discussion with your spouse over all of these issues. And, you know, these are discussions that are difficult. The divorce process is not an easy one. These are difficult conversations to have. They have big ramifications on your future life, both financial and personal. And it can be very hard to talk to your spouse. I do this every day with people. I recognize this. It's a difficult conversation to have. Your mediator is a professional with skills and an ability to help you work through that discussion. And finally, your mediator, who in most cases has a great deal of experience in this area, can help you problem solve and brainstorm solutions to the issues that arise. And that again goes to, you know, in my case, I've been doing this for almost 30 years. I've helped hundreds, if not more, people work through these issues. So I've just seen and helped craft a myriad of different ways of dealing with all kinds of things that can come up in a divorce. And it may be things you haven't even thought of. And I can tell you what I've seen other people do. Now, that doesn't mean that's what you should do, but as a starting point for your conversation or for your ability to think of come at issues from new ways, that can be incredibly helpful. So overall, your mediator is there to equally support the two of you by carrying out all of these functions to guide you and your spouse to a place where you two come to agreements on all of these issues. And that's really the final step of the mediation process, is where you are able to craft an agreement that puts your entire puzzle together. Because you will see as you go through the process that the financial side works with the custodial side, which works with the financial support future issues, and it all works together. It's very hard to settle a case or come to an agreement in a vacuum of each issue one at a time, because they usually work holistically together. And that's another area that your mediator is there to help you see as you're focusing on this individual puzzle pieces, to keep you aware of and focused on the overall puzzle together. So that's you know, the final way that the mediator will help you. And then once you have that agreement, it is required that it be reduced to a written contract between you and your spouse. Just like any other contract that you enter into, it is in writing and it fully outlines all of the agreements that you reach in your mediation process. Now, if your mediator is an attorney, your mediator can draft this contract for you. In California, if your mediator is not an attorney, in my opinion is I don't think that under the rules they're permitted to draft your agreement, but that does not mean that they cannot. There are non-attorney mediators, some mental health professionals, some financial professionals. In those instances, what they will create for you is something called a memorandum of understanding. That is a document that's a very detailed listing, but not a contract, that you can take to an attorney and have an agreement drafted for you. But ultimately, this agreement is what will be submitted to the court as a final agreement of the parties, and which will allow you to finalize your divorce as one of the 95% of people who have come to an agreement. And this is the agreement that will outline your rights and responsibilities to each other and to your children as you go forward beyond the divorce. So, you know, one of the things I haven't talked about with respect to the advantages of mediation is the positive effect that it can have on your children. Because one of the biggest predictors for difficulties for children whose parents are divorced is the level of conflict between their parents. And this is, you know, in study after study, and certainly what I have seen in the many years I've been doing this, is the more conflict that mom and dad have, or mom and mom, or dad and dad, but the more conflict the parents have, and it doesn't have to be conflict over the children, it can be conflict over the couch, it can be conflict over, you know, anything. But the more conflict between the parents, the more difficult not only the divorce process is for children, but honestly, post-divorce life for children. It has been shown, over and over again that children who have contentious parents, parents with high conflict, they're going to have just more issues later in life. So the mediation process is built upon helping the two parties, in this case parents, find a way to work together to compromise and cooperatively reach agreement. And while they may in the divorce process, mediation, be talking about their finances or their stuff, their property, they are still establishing a new way of cooperatively working together. And that not only means that during the divorce process, there's less conflict and the children are not exposed to the parental conflict, but it also means you're establishing this new way of going forward so that when after the divorce things come up, because especially if you are parents, things will come up. Children are not static, their lives are not static, and things will change, and you will want to change things about your agreement as appropriate. If you've established this new communication pattern through mediation, you have an ability to then go to your ex-spouse, now your co-parent, and work something out. Whereas, as if you remember, we talked about that institutionalized conflict cycle. If you proceeded through that process, your instinct and your learning is to go back to that process, start it all over again, and reinitiate the conflict cycle, which results in more conflict for your children. So I bring that up as the last positive of the mediation process because I think it's one of the most important, because your divorce is a finite time. It is a difficult time. It can be long and drawn out, or as I pointed out, it can be hopefully shortened with a mediation process, but it is a finite period of time. And the goal is to get you to the end of that period so that you can all go forward in a better way post-divorce. And the mediation helps you set up that ability to do that, both for yourselves and for your children. So I'm going to do the bonus information section of this month's webinar, which is child custody and parenting plans. So for anyone who doesn't have an interest in that, thank you for participating today. I will be having another webinar again next month. It will be on May 24th at noon. And the bonus topic next month will be spousal support. Thank you for participating, anyone who wants to leave now. And for those who are staying, I want to give you some brief information on what you need to be considering and what you are facing if you have minor children and you're getting a divorce. So first, just child custody, because there are many misconceptions about what this means in the divorce context and in the legal context. So in the legal setting, in a divorce situation, there are actually two types of custody. I'm going to talk about child custody first. There's legal custody and there's physical custody, which is a bit of a misnomer. I'll go into that when we get there, but I'm going to start with legal custody so that we all understand exactly what that means. Legal custody pertains to the parent's legal right to make decisions, to participate in decision-making around all the major decisions in the child's upbringing. And those are things regarding a child's health, education, religious training, general welfare, but the major things that go to your child's upbringing. And almost every state, if not every state, certainly California and Connecticut where I practice, both those states have a presumption at law, meaning there's a statute that says it is presumed that joint legal custody, i.e. equal decision-making between the parents, is in the best interests of minor children. And best interests of your children is what guides every court. That is what a court's looking at when it makes custodial decisions or any decision regarding the care and custody of your children. So as you walk into the legal process of divorce, with respect to the custody of your children, understand that there's a presumption that joint legal custody is what's best for them. Now that presumption is rebuttable. One of the parties can seek what is known as sole legal custody, meaning that party alone has the legal right to make the major decisions regarding a child's upbringing. I will tell you that is a rare occurrence. It hardly ever, I can't actually think of a case that I've had in any recent year where sole legal custody was awarded by agreement. These are sole legal custody cases are the down and dirty custody cases where one of the parties is basically saying the other party shouldn't participate in such an important aspect of the child raising. It is a rebuttal, as I said, the joint legal is rebuttable. The party who wants sole legal custody has the burden of proof. They have to come to the court and they have to prove that it is in the children's best interest that the other parent not be permitted to participate in that decision making. Now that's usually in cases where for an organic reason that other parent is not able to participate. That's usually mental health problems. That can be drug abuse or alcohol abuse issues. That can be where a party for certain reasons is just unavailable. Cases where one party is incarcerated. I have had other cases where we've had a parent sadly just disappear, just not, take off and not be a participant in their children's lives anymore. Rare occurrences, obviously, but they happen. And in those cases, a court can decide that the best interests of the children are served by that one parent having the decision-making process. Again, usually the result of a trial or a hearing of some kind, usually involving more than just the parties' opinions about this. It usually will involve mental health professionals, psychological evaluations of the parties and the family and the children. Court services can be involved, and this is a very lengthy, expensive, drawn-out process. But vast majority of people will go to judgment in their agreement with an agreement upon joint legal custody. And that leads to then physical custody. And what does that mean? So back, when I first started practicing law almost 30 years ago, we had a situation where we maybe had what you would call a more traditional situation where we had stay-at-home parents and go-to-work breadwinner parents. And you commonly saw parenting plans that said physical custody to one party who was the stay-at-home parent, and then the other parent would have visitation with the children, say every other weekend and one night during the week. And that was sort of a norm when I first started practicing. And that really sort of emphasized one parent's role and kind of de-emphasized the other parent's role. And I have to say, at least in my experience, there has been for a number of years a trend toward acknowledging the important role that both parents play in the children's lives on an ongoing basis, with reference to physical custody. So I am certainly seeing much more as a norm where you would see findings or agreements regarding joint physical custody, meaning that both parents equally have the physical custody of their children, but then with some sort of day-to-day access schedule. And that would be what we're going to talk about next, which would be the parenting plan. Now, I will note with physical custody, there are sometimes, even with joint physical custody, special designations in there to cover certain situations. One that I commonly see is where the parents live in different locations and they desire that the children go to the school district in one parent's area. So the court orders might say that for educational purposes, the party who lives in that school district will be the physical custodian so that the child can take advantage of that particular benefit. And that can flow to other things. So we have those situations, but often it becomes a matter of joint physical custody, but then as a practical matter, where are the children going to be? on a day-to-day basis? Which parent will they be with? And that leads us to the parenting plans or access schedules. And this is really many things, but it starts with the day-to-day schedule. Just on a basic calendar, where will the children be each day? And this takes into consideration a myriad of factors, but really both parents' availability to be the custodial parent, as well as the children's schedule, how far apart the parents live, so that, you know, going back and forth between the households becomes an issue or not, depending on how close the parties are, where the children are going to school. So that's one of the first things that you need to look at, is just what works for this family, what is practical and appropriate, taking into consideration the age of your children. It's easy to move a 2-year-old around because they don't have school perhaps in the same way, but a child who's attending school, you know, in elementary school or older, it may be more difficult to transition them between households all the time. So there's a basic schedule that is established as to where the children will be. And there's the benefit of this is initially it gives everybody that continuity. Everyone can plan, everyone knows, everyone has an understanding, including for the children who continuity is very important. It lets everybody know, well, if it's, you know, as an example, it's Tuesday, it's dad's. It's Friday, it's mom's. It's this weekend, it's that weekend. Everyone knows where the children are supposed to be. Now, I always mention that this is a default or fallback schedule. You put this schedule in place and it's there to be followed unless you agree to change it. The parents can always vary from the established schedule by agreement. There is no one from the court who's going to come and stand in your home and make sure you're following that agreement or that plan, you know, verbatim. So if the two of you agree for whatever reason that although it's, hey, your weekend, but the other party has a family wedding, so you're going to say, no, go ahead, take the kids, you two can agree to do that. It's conducive to your open and free flow of cooperating with each other to address ongoing issues. But, and this is really important, if you don't agree to change it, you do have it establishes then what will happen, because it is a court order. So if it says on the schedule in your court order that it's your weekend and you have plans, something special, whatever the case might be, but the other parent asks for that time, but you really don't feel that's appropriate, the default is it will be what the schedule, what the court order says. And that actually is truly important because it reduces conflict. Because if you have a court order that just says, well, we'll agree on where the kids will be, they'll flow back and forth between our households as we agree, you have no fallback if you don't agree. And that will happen. Sooner or later, there's going to be something where the two of you just don't come to an agreement on where the kids should be. And that now you have limbo if your court order doesn't have this basic fallback schedule. So in all cases, it is recommended to have at least a minimum basic schedule in place. Other things that can be covered in your parenting plan, and probably should, again, trying to reduce conflict or opportunities for conflict in the future, would be to cover your holiday schedule. Where, you know, are these different and special days that are carved out of the basic schedule? Travel and vacation schedules. Are you going to make plans for summer vacations or travel out of the country? These are things to talk about. The more you talk about in your mediation session or in your negotiations and resolve how things will be handled, the less opportunity there is for conflict in the future. What activities the children are going to participate in, who can attend those activities. The right of first refusal is a common clause added in parenting plans. That is when the children are scheduled to be with one parent, but that parent for some reason is unable to be with them, rather than engaging a third-party caregiver, which would be the requirement, they would first contact the other parent to see if they would like the ability to be with the children during that time period. And that can be defined as, unable to be with the children overnight or for an 8-hour or more period, or some parameter around that. But certainly that is something that people will often include in there so that each parent is having as much time with the children as possible. It's not a requirement. Relocation clauses. So relocation of one parent after the divorce to a remote location, and that can be many different things. What is remote to one family might not be remote to another, but those are really difficult questions, because now you are physically taking the children away from one parent in some aspect. And is that possible? Is that right? Is that in the children's best interest? So some people, to the extent that you are able, will include some relocation language or some parameters around, how a relocation question will be handled if it comes up, so that, again, even if you don't have a resolution of that issue, you know how you're going to approach it. And finally, in most successful parenting plans, certainly ones that parties reach in mediation, there is almost always a clause about dispute resolution in the future. Usually it would say the parties will return to mediation to resolve any future issues that may arise as a result out of their parenting plan. And again, this is all done to reduce the conflict so that the children are impacted as little as possible. So the parenting plan can be as detailed as the parties wish. And in fact, there are a lot of benefits to thinking through these things in advance of the actual issues arising. These can always be changed, and always be, the parties can always agree to change them in the future if they don't work. But at least having that fallback schedule eliminates the possibility of conflict in the future. So that brings me to the end of today's webinar. I hope that you found it to be helpful to you. Here is my contact information. If you have any questions that come up as a result of what I've talked about today, or anything about divorce or mediation, please do feel free to reach out to me. I'd like to be available to you as a resource, and we'll try to help you as you are making your decisions to move forward. I would like again to note, I do have this free webinar once per month. Next month, it will be on Thursday, May 24th at noon. If you know anyone who would benefit from this information, please feel free to let them know about it. I also do post a link to this particular webinar on my website so that you can view it again if you want to see any more information, so that you can forward it to someone who you think might benefit. And importantly, so that if you are contemplating mediation, you can show it to your spouse and they can hear the exact same information, the exact same recitation of what I have told you here, so that they feel that, again, they've heard a very neutral and equal idea